All right, we're going to deal with case 25 CR 1313 first. This matter scheduled for an arraignment. Mr. Atwater, did you receive a copy of this indictment charging you with the 2 counts of failing to appear?
Yes, Your Honor.
Have you a chance to look that over?
Yes, Your Honor.
You have the right to have me read that indictment to you, and I'll do that if you'd like me to, or you can waive the reading. What would you prefer to do at this time?
Waive the reading, Your Honor.
Very well, then as to those 2 counts, how do you plea at this time?
Not guilty.
All right, the court will enter a plea of not guilty. And I'm going to set bond to $10,000 cash surety. All right, now in regards to case 25 CR 127, Ms. Smith, is there any reason not to go forward with sentencing?
None that I'm aware of, Your Honor.
Is there anything you'd like to say on behalf of your client?
I would, Your Honor. Mr. Atwater is before this court on a failure to comply case. Mr. Atwater is a veteran. He served in the Marine Corps. He was twice deployed, suffered a traumatic brain injury that was documented from an explosion. Prior to finding himself before this court, he was established with services with the VA, attending once a month and working on obtaining a therapist. Your Honor, Mr. Atwater's PTSD kicks in as fight or flight, and for him it registers with flight every single time. It's how he came before this court on the underlying offense. It's how he came to flee his sentencing hearing, was re-entering the country from Canada after fleeing to see his family for the holidays and then turn himself in. Obviously, he was unable to complete the first part, but he is before the court humble and apologetic. It was offered that there was a joint recommendation for community control in this case. Mr. Atwater also pled guilty to an OVI. His drinking is as much tied to his service and his resulting disability. He would like the court to consider the role that his PTSD does play in each of both the offenses to which he's pled guilty and the
Well, you're asking me just to assume that. I have nothing about that. I gave him an opportunity to provide me information on that, but he chose not to do that.
And Mr. Atwater understands that the only reason that the court is...
So my point is you're offering these explanations, and I guess I'd like to take your word for it, but I don't have any...
Am I allowed to speak, Your Honor?
You'll give a chance in a moment.
And Your Honor, that is the purpose of a pre-sentence report, and that's why it was critical take place here. It did not, and it did not because Mr. Atwater did not appear. And so, Your Honor, we are asking for leniency in the prison sentence that is imposed. Mr. Atwater does not have a criminal history. He does have a record of service with this country as a veteran.
Thank you, Ms. Smith. Mr. Atwater, you have the right to address the court before you're sentenced. You can say anything you want. Is there anything you'd like to say at this time?
Your Honor, I'm deeply apologetic for the decisions I've made, and this is the most trouble I've ever been in my life. A lot of these terms are very new to me. Please, cop and please, just the whole situation is I was completely oblivious to. So
show up to probation by 9. That's confusing?
Not confusing, just wasn't feasible, Your Honor, because there was...
And you shouldn't have stayed in jail. I gave you a bond because you told me you'd be able to do it.
Your Honor, this is the most time I've ever been in jail. It's a terrifying, scary situation. I have kids. I've never been away from them besides the time of me being at war. And I felt like the time I had spent in jail was worse than war. Like, it completely was. I don't have anything as far as, like, to say. When I said I could show up, I was planning on finding a way. My mother was out of town. She was in another country. And I was just under the influence. I wanted to get out of jail at that time. And I tried to find a way, and it didn't work out in my best interest, Your Honor. I'm apologetic about that as well. I don't go out with any ill intent of doing harm to nobody. I've never stole from anybody. I don't be in the world doing anything wrong. The one thing I did on that instance in January, all I was doing is trying to avoid a confrontation at home. I went to the bar, I drove home, and that was and this situation ensued. There was no craziness as far as I'm not out here doing anything wrong, just trying to raise my kids. I take my kids to football games, cheerleading practice, you know what I'm saying, the normal dad stuff, and just try to live in the world as peacefully as I can. I've been to 3 different trade schools. I do home renovations. I do a lot of different things to not be in trouble or getting in this type of situations. That night was me trying to avoid a situation, and it happened to be this is what happened from it. So I apologize for just the whole situation in totality.
All right, thank you, sir.
Thank you, Your Honor.
Ms. Smith, anything else?
Not at this time as to this matter, Your Honor.
Well, Ms. Linden, on behalf of the state.
Thank you, Your Honor. Your Honor, I know we did originally say we were going to have a joint recommendation for community control, but the problem is if you're going to be on community control, you have to show up. And it's clear that that is a difficult thing for the defendant to do for whatever reason. So the state is recommending a prison term on this matter. He does have 8 days of credit for time served. There is a requisite driver's license suspension on the failure to comply of 3 to life, and then on the OVI of 1 to 3 years. There's a mandatory 3 consecutive days for the OVI, and then a mandatory fine as well. So we'd ask that you impose those. Thank you.
Thank you. Ms. Smith?
Your Honor, it's my understanding that Mr. Atwater has 8 days of jail time credit since his arrival.
Yeah, that's exactly what I'm doing right now.
Okay.
Let me see what I get. Do you have a number?
I do not.
I mean, I'm looking at the docket. I mean, his bond's been revoked 4 times in this case. So back in February of this year, there was a motion to revoke his bond that was granted. The warrant was issued on February 19th, executed on the 20th. So he was arrested on February 20th. Then there was a hearing on a motion to reinstate, and a judge reinstated it at that time, but that's 5 days there. 20th, 21st, 22nd, 23rd, 24th. So that's 5 days in February, 3 days initially. He was arrested on March 31st. Motion to reinstate was filed, and that was granted on April 8th. And he was arrested on the 7th because he showed up late for the change of plea. We got him in the next day for the plea, correct, on the 8th?
Yes,
sir. That's when he was released. So that's the 2 days you have there. And then you're saying he was arrested on 11/24,
yes.
So today, 3 more days.
22 then?
I don't know yet. Oh yeah, 22. I don't have a pre-sentence report to review as an psychological evaluation that were ordered by this court as the defendant failed to appear to the probation department to assist in the preparation of those reports, which would benefit him, benefit the court. I've considered everything that's been said here today by Mr. Atwater, his lawyer. For the factors in 29-12, nothing stands out factually in regards to the stated factors. However, the court will note that for the fleeing and eluding charge, the defendant was operating the vehicle under the influence of alcohol or drug abuse at that time, which makes the fleeing charge more serious. Nothing makes it less serious. As for recidivism factors, the court notes, while the defendant may not have a criminal history, he has a horrible traffic history with multiple driving under suspensions, which just coincides with the conduct here throughout, just not following rules and not following orders and court orders. And he just does what he wants to do. Appears to be an alcohol problem, at least related to this offense, and hasn't done anything to address it. I don't find genuine remorse. I could find genuine remorse just coming here today and saying I'm sorry, but the conduct and your behavior leading up to this shows no remorse. And other factors indicating relevant factors, just the fact that the defendant's bond has literally been revoked 4 times in this case. First, sit down, please.
Okay. Yes, sir.
First 2 times, it's because he wasn't able to pay for whether it was Scram or GPS, I don't remember which one it was, and it was revoked and reinstated. And it got revoked and reinstated. Then in this case, he shows up late for his plea, so it was revoked and reinstated. I've never seen that happen before. Someone's had their bond revoked 3 times and then been reinstated every time. And that's part of the problem here. You think you can just do what you want to do and you're going to get what you want, and then I'll end run. And then it was violated, revoked again because the defendant, when he got reinstated for the 3rd time, he was told to show up the next morning by 9 a.m. He didn't show up. Didn't call. Didn't come the next day. Didn't reach out at all. Said you didn't have a ride, but nobody knew that. You didn't call anyone to tell him that.
I was under the influence. I was going to jail, Your Honor. That's all.
It's not an excuse.
Not an excuse. And I feel like there was a lot of miscommunication with the scram monitor because they said they was going to pay for it, and then I got bound over to Lake County, and then they never told me that I had to pay for it. That's where all that miscommunication came from initially for the scram.
Even the second time?
Yes.
When you got revoked and then again it was reinstated? And you said you would pay for it?
I was paying for it, Your Honor, but they didn't tell me that I had to pay for it. It was surcharge every day. So I was paying for it weekly, but by the time I paid for it the next week, they were saying that I was late. That's what that was about.
I know what it's about.
I didn't know that I had to pay for it ahead of time.
No, you keep saying you don't know this stuff, and that stuff's explained, but you just don't pay attention or you don't want to hear it. You claim I didn't know I had to be there by 9 o'clock, or maybe it was your girlfriend who called here. Your girlfriend that called here and said it was never told what time he had to be there on that day. Well, that's
I knew I had to be here at 9 o'clock, Your Honor. I just didn't have a ride from Cleveland.
Bond's been revoked 4 times. You've had multiple license suspensions because you just do what you want to do.
All I've done was go to work, Your Honor.
I gave you enough. You say what you want to say because it's my turn to speak, but apparently you have more you want to say. So I'm going to let you say what you want to say, but then it's going to be done. We're not going to go in this debate here.
Yes, Your Honor.
Is there anything more you want to say?
No, Your Honor.
So his bond was reinstated when after he showed up late for the plea. Didn't show up to any of his appointments. Didn't call, reach out, and do anything. Showed up for his sentencing. And he left. And he's been gone September, October, November, over 3 months. 3 months.
Terrible person, I am. Terrible person. Worst person. No.
Attempted to leave the country.
Never left the country.
I said attempted to leave the country. We're not having a debate. I said attempted to leave the country. You're going to leave the country.
I never attempted to leave the country.
Your attorney just said it. And I knew you were arrested or someone trying to get near the Canadian border.
No, I was not, Your Honor. That is false information. I was arrested at home. I don't know where Canada came from.
From your lawyer's mouth.
It was relayed to me by the state, Your Honor.
Your Honor, I can tell you from what the marshal said.
I was at home.
So in terms of...
You're going to be removed from this courtroom if you're not going to keep quiet.
Yes, Your Honor.
I've given you every opportunity to speak. I've asked you multiple times if you have anything more to say, and I said we're not going to argue back and forth, and you keep doing it. It's the exact history of what this case is about, that you just do what you want and don't listen to anybody. Ms. Linden?
The information from Josh Robertson from the sheriff's office indicated that they had to ping his phone, that they got the phone number that was pinging within 25-meter radius of Windsor, Canada. It was across the river from Detroit. He had to reach out to Border Patrol to see if he's crossed over, and they were looking at a provisional warrant to give to Canada as a result of that. There was a Canadian counterpart that they were trying to get in touch with as well there. They were going to continue to ping the phone, and then he appeared to be the next day back in Detroit, and they were going to reach out to Detroit at that point in time, and then they continued to ping his phone, and then he was finally got apprehended.
Thank you. So again, there's a history here of not complying with the court orders and rules. As for factors indicating recidivism is less likely, the court notes the defendant doesn't have any criminal history, led a law-abiding life for significant, he doesn't have a criminal history. I'm going to say he's led a law-abiding life because he's got a horrible traffic history, and that's not following laws or abiding by the laws. Again, the defendant failed to appear for a pre-sentence report, so I don't have a report that was completed, and thus I don't have under the law, the authority to impose community control sanctions. When I look at the history of this case and what this whole thing is about, there's no way the court could find the defendants amenable to community control sanctions. The very offense itself deals with failing to comply with an order of a police officer. Defendant's bond again was revoked 4 times in this case. The history here is that he doesn't comply, doesn't follow rules, and is going to do what he wants to do. So prison is consistent with the purposes and principles of sentencing. Therefore, it'll be the sentence of this court that on count 1, defendant serve a term in prison of 12 months. Count 2, he serve 180 days. By law, that must be concurrent. So 12 months in prison. He has credit for 22 days he's already served. Need to advise you upon your release from prison, you may be placed on post-release control for up to 2 years. If you are and you violate any of those conditions, the parole authority can return you to prison as punishment for violating their rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half the term I just imposed, which would be 6 months. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Court disapproves defendant's placement in a program of shock incarceration, intensive prison program, or transfer to transitional control. There's a mandatory license suspension for both counts that's required. I'll suspend the defendant's license for count 1 for 3 years, which is the minimum. 1 year in count 2, there'll be a concurrent suspension. There's a mandatory fine in count 2 that must be imposed. I'll impose the minimum fine of $375. Defendant's also ordered to pay all costs. Is there anything else for the record, Ms. Linden?
No, Your Honor, thank you.
Ms. Smith?
Your Honor, only that in case number 25 CR 1313, Mr. Atwater has executed a waiver of speedy trial in the bond conditions and presents
Okay,
those to
we'll
the
get that
court.
filed. Thank you. Anything else?
Not at this time.
Thank you.
All rise.